What is the importance of the rule of law in Kenya? The rule of law can simply be referred to as statutory provisions that have been passed by the bodies mandated with that duty, including government cabinet secretary acting within their scope of authority as per the assigning legislation. Regardless of the authorizing legislation, rules, policies or regulations, the Constitution of Kenya takes precedence. Therefore, in the event a legislation, rule, policy or regulation is contrary to the Constitution, a court can declare it unconstitutional if its powers are invoked. It is important to note that in certain instances, even when the court declares a certain practice to be unconstitutional, the offender might be given time to sort out the unconstitutional act or omission. A good example is the recent decision by the High Court on how Kenya Revenue Authority does tax imported vehicles. Lastly, the law, in Kenya and any other part of the world, does not exist without other influential factors like politics, social, cultural and economic factors. Therefore, while it is not widely admitted, these factors immensely have an impact on what is referred to as the rule of law. Customs in law is the established pattern of behavior that can be objectively verified within a particular social setting. Customary law is a body of customs and traditions which regulate various kinds of relationship between members in a community. The Judicature Act Section 3 subsection 2 says that customary law is applicable to the extent that they are not repugnant to justice, morality or any written law. Customary law content is diverse, changing from village to village. Customary law is used as a guide in civil cases affecting people of the same ethnic group so long as it doesn't conflict with written law. Both custom and law are the realization of the measure of society's insight and ability and also the principles of right and justice. Customary law is referred to by a number of names in literature: native law, sometimes as native laws and customs, native customary law, primitive law. Application of customary law in Kenya. The Constitution of Kenya 2010 has stated the following under Article 2(4), that any law including customary law that is inconsistent with this Constitution is void to the extent of inconsistency and any act or omission in contravention of this Constitution is invalid. This means that the application of customary law in Kenya is subject to provisions of the Constitution and any other written law. In most African countries, customary law is the law that regulates the life of most people, particularly in rural areas. Example: when it comes to matters on succession, the Law of Succession Act provides that the succession law that governs succession will be the one in the act. But when someone dies, the people follow customary law because succession is a personal matter, same for marriage. The fact that customary law is able to survive hand in hand with the statute is indicative that the statute does not reflect the values and the norms of the people. That is why they still go back to customary law. The argument has always been that customary law seeks reconciliation, and when you go to court you make enemies, and that is how we look at it in the African sense. Court's jurisdiction in customary law. Unlike some other African countries, Kenya has no special customary courts. However, the various courts in Kenya have varying levels of jurisdiction in customary law. Under the Constitution, the High Court has original unlimited jurisdiction in all civil and criminal matters. Though not specifically stated, this jurisdiction includes customary law jurisdiction. This means that it may hear any civil matter based on customary law. The Court of Appeal hears appeals from the High Court on all matters, including customary law matters. As the High Court and Court of Appeal are not expected to be experts in customary law, they usually rely on the evidence of witnesses and also on independent assessors to enlighten them on the content of customary law. They also pay high regard to the restatements relating to customary law of marriage, divorce and succession. There are numerous cases in Kenya that show the roles of customary law, either generally or in relation to specific issues. The roles of customary law may be positive or negative for women, depending on the effects of such roles. One of the most famous Kenyan cases, the SM Otieno case. Some specific areas where customary law plays its roles include: roles of customary law in Kenya. Succession. Although the Law of Succession Act is intended to be the universal law applicable in matters of succession, customary law is to some extent also applicable. As later discussed, some geographical regions of the country have been exempted from the application of the Act, and in these regions, customary law is the applicable law relating to succession to agricultural land and livestock. Discretion has also been left to individuals to indicate in their wills any religious or customary law that they would wish to govern the administration of their estates. Customary law is also applicable to estates of people who died before the commencement of the Act in April 1981. Outside the above situations, there remains controversy as to whether and to what extent customary law is also applicable in succession matters. Some courts have insisted on the exclusive applicability of the Law of Succession Act, while other courts have maintained that customary law is generally applicable in succession matters, even where there is no express provision for it in the Act. Under this approach, customary law has been applied to deny women the right to inherit their father's or husband's estate. Mary Gichoru v. Esther Gachuhi. In this regard, courts place much reliance on the assertions in Cotran's restatements on the content of customary law. Some courts have taken the view that customary law is applicable provided it is not repugnant to justice and morality.